Thanks everyone for joining us today for this webinar. We're super excited about it. We've had these guys do this sort of training in the past and it was super popular, so we wanted to make sure we could bring them back for as big of an audience as we could get them. I'm Liam Threlkill. I'm with the Utah League of Cities and Towns. We have Ryan Luce, who's the city attorney with South Jordan, and Stephen Schaefermeyer, who's the director of planning with South Jordan, who are here to talk with us a little bit about development agreements. I'm going to turn it over to them here in a second. If you have questions as we're going throughout, please put them in the chat and in the Q&A, and we'll do our best to answer those as we're going along. With that, Ryan, Stephen, go ahead.
Thank you. So I started at South Jordan in about 2014 in Ryan's office, and I moved over to planning with my undergrad in urban planning. I'm now the planning director, but have kind of a background in this type of thing with my law degree. So hopefully we have some good information for planners and attorneys and elected officials and appointed officials, other city staff. If you have questions throughout this presentation, just interrupt or put them in the chat box, and then Liam will interrupt and ask your questions for you, and we'll hopefully have a decent answer for you. Like he said, we've done this to a couple different audiences, so it's unclear exactly who's on here, but we are open to any and all questions, so just send them our way. So I'll just dive in. We don't have a lot of slides, but I wanted to start with a story. This is an apartment building in South Jordan. If you're familiar with South Jordan, this is near I-15 and 104 South, or South Jordan Parkway. So this is on the west side of I-15 across from the Southtown Mall. On the other side of the street, Jordan Gateway, that this fronts onto is a front runner station, just to kind of orient you the context of this development. Now, this is a phase 2 of a performance development. Phase 1 is essentially all the buildings except for the building in the foreground. So those buildings were built. And then we came into phase 2 of the development. The context of phase 2 is it's essentially on a cliff. It drops off pretty steeply from the property into protected lands that are part of the Jordan River corridor. And so that becomes significant as I kind of tell you this story. So hopefully most of you are familiar with performance development. Essentially, if a developer or landowner wants to get some additional benefits, be that density bonuses or other things, they come to the city under this scheme of zoning and suggest some benefits, some amenities. It could be everything from affordable housing to public spaces. There's a variety of ways that you can meet the performance part of this development. So between phase 1 and phase 2, the city council had kind of been shaken up a little bit. And so some of our mixed use zones, our performance zones, they were under heavier scrutiny by our city council and some of our citizens, and a lot of questions about the outcomes that were promised and the outcomes that they were seeing under those zoning schemes. So under phase 2, the developer came in, and again, this was heavily scrutinized by many in the community. They proposed, as you can see, a beautiful rooftop garden, an infinity pool, better materials, and a tiered retaining wall, some other things that they came in with as promises. It got a little heated there towards the approval. I remember sitting up on the Diaz as representing the city in the attorney's office and having an attorney that you all know and love at the Diaz representing his client. And we had met earlier to, again, go through. This also required a conditional use permit. And so there were layers to this approval. And ultimately, it did get approved by our planning commission. Where the story becomes significant and how we'll lead into our discussion about development agreements is And to be clear, there was no development agreement for this. It was all just under standard performance zoning. But as the development got going, this is, again, some of the elevations that they submitted. As the development got going, after they received building permit approval, suddenly things started to change. The first and most significant one is what you see in this picture. So this is the project actually built. And hopefully you can tell a difference. I'll just toggle back between this and this. It is a different outcome than was expected. In this rendering, you see some bushes and trees, kind of a tiered retaining wall that's softened by some greenery. And then there's this. And overall, I'll just say the overall development is not bad. There are a lot of great things about this development. It provides housing, necessary housing near our transit station. And there's some other good things about this development. However, as you drive east towards the freeway, if you look to your left, we have, the beautiful open space of Jordan River Corridor and this massive retaining wall. We've tried to work since with the now property owner to soften that retaining wall. Efforts have not been successful. We're still working on it. It may be one day a spot for a community mural. That's the latest idea, to soften this retaining wall. The other thing that happened that you can't see is the rooftop garden was changed. Suddenly we were told, oh, the building that we are literally halfway constructed, cannot support the design of the rooftop garden. And the infinity pool also is not supported by the design. And so we had to figure out how to get them to do something while not having a half-built building that has necessary housing that we are now telling them they cannot finish. And that's the challenge I'm sure many on this call get into as they try to work through some of these projects. Eventually we got a few hot tubs on top and some green planting on the roof, but definitely not anything approaching what was promised as part of the performance development. And
Steve,
so,
can you give them some scale on that wall? I think you can kind of see everyone, but if you look at the windows, you've got 3 to 4 stories there above the wall, and the wall is almost equal of height as those 3 stories. So all of the darker brick, the wall is about that tall. Those little trees that you see are not little, they're 12 feet or so.
Size trees. Yeah, and this property in the foreground is owned by the federal government. And so even getting them down into that area, they built right up to the property line, is difficult to come up with solutions for how to make this situation better. But the reason this story we think is instructive is this is what we got under standard zoning. And when you start getting into the actual building of the development, we already had a lot of scrutiny on these performance and mixed use zones because some of the outcomes were not what our city council and others were expecting. And so as a result, in order to preserve some form of flexibility, while some of these zones were either completely eliminated or changed, we no longer have performance zoning in South Jordan. We came up with an ordinance that allowed development agreements as part of this rezone process that specifically lay out bonuses or flexibility that can be provided to the development community in exchange for clear community benefits. And I'll say just on the outset, even though we're talking about development agreements, where possible, I always will go for a traditional zone. Where possible, I'll always go for a traditional rezone process. However, there's areas in our city, be it around transit stations or high-profile corners or difficult infill pieces where traditional zoning is, it's difficult to fit a development into that box. And so what we have now is broader flexibility, and ultimately, and probably rightfully so, our city council wants to be involved in that flexibility, in identifying what the community benefit is and what the flexibility is that we're providing the development community. And so we've been doing a lot with development agreements for larger projects. Again, I try to avoid it where possible, but they do come in handy. And I think at least from those we've talked to in the development community, they see the value in it as well. Sometimes there's more effort up front, but as you get through the development process, there are some real benefits. So let me just show kind of a very brief outline of the things that we're going to be talking about. And again, feel free to ask your questions, and Liam will interrupt us as necessary so that we can answer those. There's a lot that we can talk about with development agreements, but we're going to just try to stick to some of these things. And it's obviously a work in progress. We continue to learn the more development agreements we have and the lessons we learn. When I first was hired by South Jordan, I was asked to talk about contract negotiations as part of my interview. And one of my main points in that interview is, as tight and as well thought through as an agreement as you can have is obviously that's important. However, relationships are even more important. And so the understanding what your relationship is with that particular developer and developer community, and I know that can kind of ebbs and flows, but relationships are important. Our biggest development agreement in South Jordan is the Daybreak Agreement, our Daybreak community on the west side of our city. And we have over 2 decades of experience with that developer. And we recognize that problems are solved through relationships, not necessarily through agreements. But in order to maintain that relationship, you got to have a good basis in a development agreement. So I'll stop sharing my screen. I don't know, Ryan, do you want to talk about the statutory authority?
So we, if you look at, Steve, can you put back up that side and we'll just walk through it. The statutory authority is 109A532, and what it says, and even before this was enacted, cities were entering into agreements for developments. Now, we can't do contract zoning, and your city attorney is probably a lot smarter than me and can explain the exact difference between them. The main thing that I see is that throughout the process, until the city council votes and adopts the agreement and enacts the zone, then, and we always do it in that order, we adopt the agreement first by resolution, and then we enact the underlying zone, so the agreement's conditioned upon the zone. That way, you know, they don't refuse to sign the agreement or something and have the zone, or at least have the argument they have the zone. But from the standpoint of that authority, 109A532 allows us to do the agreements. We may not extort agreements, so they're voluntary actions. We've had this question in the past, and please send in as many questions as you want. That tends to drive the conversation when we've done this presentation. But we've had the question about how or when you do development agreements. In South Jordan, almost all, if not all, of our development agreements have been prior to the rezone. I know of instances where people do development agreements as administrative items to clarify things, but once you've enacted the zone, unless you have an agreement setting out some parameters on that zone, then you can, then they have the zone, they have those rights. You can't limit them later unless they willingly do that. So your only time to really negotiate and have that conversation with them. Right now, we're in conversations with the developer that our council wants 50% residential out of the townhomes they're building. And the developer, you know, is saying, trying to decide if he can make that work. But all of that happens prior to the zone. Once that zone's in place and the townhomes are allowed, then we can't bargain those type of things. So another part about development agreements, if they come in and just apply for your zone and want to live with the zone they have, you can't force them into it. I said you can't extort them or force them into it. So we usually get them when they want more zoning. All right, Brian says, in Provo, we offer approve the development agreement in the same ordinance that approves the rezone. But the rezone ordinance is explicitly conditioned on the execution of the agreement, and it becomes void if they don't sign within a year. The effective date of the zone change is the execution date of the agreement. And Brian, I like that advice. I like that practice. We do something similar. We actually make them sign the agreement before they come in to the city council. We want that agreement signed. We pass the agreement first by resolution, but I think you could do it as part of the rezone ordinance just as easily. And then, so we have them sign it, and it's a delivered package. We learned that the hard way when we had someone renegotiating the agreement that they hadn't signed yet in front of the council, and made a relatively easy meeting much more difficult. Got a question by Brian Del Rosario. Hopefully I said that right. It says, excuse me, our city staff insists on city council passing zone changes before development agreements. What is the risk? As an attorney, what I see the risk as, and Steve, weigh in here if you have thoughts, what I see the risk as is once they have the zone, they have the zone. And I've heard of some people conditioning the zone upon the agreement being signed. That's kind of what Brian says in his. And I think if you've got that locked up in agreement and your attorney has really lined that out, it can work. But from the standpoint, we like having it, the agreement done and then approve the zone. Now, we know if our council approves the agreement, their next item on the agenda, which is the zone, is likely going to be approved, right? They go hand in hand for us. I think the way Brian in Provo, maybe he has an example he can share as far as an agreement, and other cities do too, where they have it all in one vote, but they have it very, the rezone ordinance is conditioned upon the execution of the agreement. And if they don't sign it, it voids it out. We've just found better luck on getting it all done beforehand. That way, when we come into the meeting, when the public comments in planning commission, and planning commissions now do review those agreements, when the public comments to city council, the public knows what that agreement says. The city council knows, and planning commission knows what the agreement says. Staff knows what it says. It is signed by the developer. It is committed to by them, and we're all on the same page. And so by doing that, we can answer that, or we can answer all the questions clearly. There's no future question that may arise. The public knows what they're getting. And if they're against it, they can specifically say, I don't like provisions X, Y, and Z in the agreement. I believe Liam's going to throw up our draft agreement. We made it a template, so everybody can have it. So that's how we do it. John Brems, hey John, asks, what about amending the development agreement after approval? Is it administrative? That's a good question, John. Steve, what are your thoughts on this? Because I can tell you what we think.
Yeah, I think it depends, right? So the way that we've treated it is there a fundamental change in an entitlement? That's maybe one. There's probably other ways to say that. But so, for example, if the amendment allows them to build more units per acre, or allows a new use, or something else that's really sort of fundamental zoning questions, then we would call that legislative, and we would take it through that full process. If the amendment to the agreement doesn't really fundamentally change that entitlement, so for example, we've had a pretty clear concept plan that showed shape, size, height of a building. There were significant changes to that caused us to go back and amend the agreement. But those changes, so we wanted our council to see them and to have the agreement reflect those changes. but the changes we didn't believe affected the actual land use entitlement. It was the same use, it was the same general shape and size, location, all of those things. But there were some other significant changes that didn't really go to that base entitlement. I don't know if Ryan agrees with
Yeah,
that.
I do. What that was, Merit Medical, who's a great business here in South Jordan along Redwood Road. They own a property adjacent to their current campus that, I believe I'm speaking the same one, Stephen. And in their development agreement, they had a number of exhibits. One of the exhibits showed a building facing a certain way and it had a daycare in it. Well, their business model of what they were doing with all that changed between the development agreement and when they were ready to build. And so they said, we need to do this different orientation of the building. And like Steve said, just functional things about the building. It changed where trucks come in and out and stuff, but it did not change the use. It did not change any of the aspects of the building other than orientation, but all of the uses, all of the things that we knew, like square footage basically stayed the same. All the things we knew and that our council approved legislatively and that the public spoke on legislatively were the same. And therefore we just left, or not left, we just took that to council as an administrative change. The majority of them, we've amended the Daybreak Development Agreement a couple times. We've amended other development agreements. The vast majority of them are legislative, in my opinion, and we take them through the full process. We give the public time to talk and to give us opinion on it and give the council that legislative discretion. I think the only one we haven't done legislative was that one that I can remember.
Yeah.
So hopefully that answers your question, John. Polly McLean.
Sorry, can I just say one more thing?
Oh, please.
Yeah, so the other thing that we've added to our agreement is a minor changes provision. And that is really helpful at a staff level to, we've defined what that is and how those are approved. But it kind of bakes into the development agreement and the process that as we get into the actual building of things, there will be small issues that come up that may require tweaks here and there. And we would consider those minor. And because that's part of the agreement, it allows an approval at a staff level. We document it, we document the reasons. So if there's ever a question, but that provision has been really helpful so that we don't always, for every little change, feel like we need to go back to the city council, whether it's through the full legislative process to planning commission and then city council, or just to city council. And then the other thing I'd note on sort of the timing of these approvals is it just takes a bit more effort at public hearings to explain to people how the process is going to go and what the approval of the development agreement means. And so we've kind of massaged that over time, how it's put on the agenda. Our mayor is really good at explaining before a public hearing what the public can expect as we go through, so that hopefully, and you all know, sometimes you can explain, and people still don't understand, but we think it's smoothed the process better so that people aren't surprised when they approve the development agreement and don't really understand what comes after that.
We're going to go through some of these questions quick and then we'll get to some of the things we had prepared. But Polly, hi Polly, you asked, what do you do with the rezone if the developer fails to move forward with the development, even if they've signed? We have a 10-year expiration on development agreements. And so that entitlement would go away after 10 years. And I say we have 10 years. Obviously, the Daybreak Development Agreement and the PC zone, that was a much longer one. It was 30 years. It expires in 2034 and it was signed in 2004. So we do put expiration dates. The bigger the development, the longer that may be. So that's what we do. And it specifically says it'll revert to the underlying or to the original zone. So it's not like the agreement goes away, but you get all the benefits of that zone with the more density or whatever it is they bargained for.
And if the property's sold, we have provisions in there that subject the next owner to that development agreement. So that is the zone that's in existence within that 10-year period. And again, if they want to come back in and modify it or revert to the other zoning sooner than that 10 years, then we have those conversations.
And we also record all our development agreements. And so any potential buyer, anybody has noticed that this is running with the land, or this is on the land, and would be something they'd be subject to if they purchased it. Hopefully that answered your question, Polly. Ruth Ann Kane asked, if we have already rezoned a property, can we enact an agreement as part of their zoning building permit process? If they agreed to do an agreement, you can certainly enter an agreement with them. And this kind of goes to John's next question. Aren't administrative development agreements precluded? I believe you can still do them, John. I know that when they changed it, so you take things through the planning commission, it changed that. So if you can push me to where in the statute it says we can't anymore, let me know, but we generally don't, so it's not something I have a statutory site for, John. As far as finishing the question for Ruth Ann, if they are willing to enter an agreement with you, I think you can, but I don't know what you bargain at that time. Usually we're bargaining in the zone and they want more density, or they want a zone that generally we wouldn't put on that piece of property, whether it's setbacks, whether it's heights. Anyway, they want something in a zone, and to get that, our council generally wants something. So like what Stephen showed at the beginning, they want that nice apartment building right next to the TOD on I-15 and everything. They show us a picture and promise us all those things. How do we hold them to it when they make those promises to council? When council rezones it, now we end up with what I affectionately call the Great Wall of South Jordan. Because if you drive up to it, it is huge. It's several stories high, and you're looking at it saying, how did a council ever let this get approved? Well, they didn't. They approved something much nicer. It's just we had limited tools to enforce them.
Well, and in that case, our council wasn't even involved because it was an administrative proceeding before the planning commission.
Yeah.
And I think that's where
The zone was already there.
Right. And so that's where councils start to get a bit uncomfortable when something that's significant. And we all know it's really hard to plan for every eventuality when we write a zoning ordinance. And there's always somebody out there who's more creative than us that finds a way around it. And so this is sort of kind of the reason we're talking about development agreements and using that as an example is because the development agreement through the legislative process gets the council involved where they may not be in an administrative process.
Yeah, Lyle, everybody can see Lyle's comments there about binding future council's action. So rezone does bind the future council in that once you've done a rezone, that sits with the property. Now, a future council can rezone it to something else, but if someone's begun using that zone for that use, so they put a building there and start using it, once you've done that, it starts to lock in the use of that as a pre-existing non-conforming use. So you can change the zone to something else, but if they're there using it legally permitted, then they can keep doing it for a time. And so as far as locking in a future council, you can't commit budgets, you can't do things like that. Like once upon a time here in South Jordan, we had a council member who passed a resolution to encourage future city councils to always keep our rainy day budget at the full amount. And that was to encourage them. He couldn't pass a law to say you have to, and that would bind them. But with land use, once that zone's changed, someone can exercise all the rights in the zone. And even if you change it later on, if they're using it for the rights legally permitted at the time, they can continue to do so. Steve, was that accurate as far as your understanding of the law?
Yeah. One thing I wanted to add as well is obviously you shouldn't be putting in development agreements that a future council will do a subsequent rezoning or commit to a future legislative act. And I've seen, some that try to bind a council in that way, but it doesn't work.
Yeah, and Victoria, yeah, I agree totally with Victoria's comment. And I thought I saw that Brian or somebody posted their development agreement too, but I think ours is posted in there. I just can't see if another one. Doing it after rezone is done raises issues of illegal exactions and arguments, is for lack of consideration if get something done in exchange for whatever the agreement obligates them to do. I agree, Brian. That's why we kind of do that. And then we have an anonymous attendee question. Are development agreements recorded so it is found on title searches? I can't speak to how every city does it. We always record ours. In fact, that recording helped us just this week in finding an amendment to one of our agreements that no one was sure was out there, and we were able to find it through the recording and kind of make sure we were all on the same page with the developer.
Definitely best practice, and the state law 532 talks about allowing communities to
Record it.
quarantine. Yeah.
Yeah, it says in subsection E, a municipality may submit to a county recorder's office for filing a fully executed agreement or a document related to, and then it has a few items there. So, I don't see any new comments or notes. One of the things that we talk about a lot here is who negotiates development agreements. Sometimes I'll get a call from an attorney, working for a developer and saying, hey, Ryan, what's your council's appetite for doing X number of units per acre on this corner? You know, and then I'll say, we'll talk about what the use is a little bit, but I'll direct them to Steve's group because he's the planning and stuff. A lot of times it comes through to Steve's group first. But one of the things we stress is we try to speak as staff with one voice. Now, we have the overlay zone that Steve talked about, and that involves council at a high level. And so more and more, we're seeing developers go to our council members directly, individually, and start to negotiate with them. And we ask our council, and our council, I think, is very good at including us throughout the process, because we've learned if we can speak as one voice throughout, then we can share, or then the development process goes smoother. The more they divide and conquer, the more it creates issues later, as this council member told them that, the mayor said that. And so very rarely do we get that anymore, because our council tries to speak as one voice and they try to loop staff in. And a lot of times, in several cases, they just say, you know what, talk through staff, and we have work sessions and stuff with the developers. Another thing we're seeing a lot is lawyers who work for development companies saying they're the entitlement agents for the company. And they come in and they start negotiating on behalf of the developer. And really, they should know. And if you know that you're dealing with an attorney and you're a planner, even Steve, who's an attorney, when he deals with them, the first thing he does is he alerts my office, and we invite one of our city attorneys, someone from my office there, to help be part of that. Because I mean, Steve did the job, could do the job, but he's in a planning thinking mode. And he doesn't want to concern himself with the legal aspects necessarily, if we can get someone there to do that part. But we're seeing that more and more, where lawyers are involved on behalf of the development company, and negotiating these deals. The other thing is, often they want to go into closed meeting. And in closed meetings, we're talking about dedication of parks, of roads, different property things. That's usually how we get in closed meetings with developers. I personally, is just something I like to do, is have a talk with their council beforehand to assure they understand closed meeting law. And to assure that they, since many times they know more what their client's going to present than what I do at that time, that they know what the presentation is, and that they'll keep their client on track. Because nothing ruins a closed meeting faster than when they get off on stray thoughts that are clearly not something I can protect under closed meetings. And I've had to interrupt on more than one occasion and say, we're straying out of what the purpose of the closed meeting is for. If you want to continue this conversation, you need to move to go into open meetings, and then you can continue conversation. And while my counsel gives me grief about that all the time, they appreciate it. They appreciate me limiting that, or I appreciate it when I can get the attorney for the developer also on board, and that attorney and I can kind of keep things in bounds.
I'll
Just to
just,
finish up, go ahead. Steve.
I was just gonna answer Mike Malloy's question.
Let me
about-
finish up on negotiations and let's
That's
jump to
great.
that. 2 points more I have on negotiation that we do is almost always we start with the city drafted the agreement. We let developers do quite a bit of revision and stuff. Our draft is not perfect. It's not the be all end all, but it gives us a framework where our planners understand what they're dealing with and where we can come in and negotiate within bounds. We also generally try not to negotiate until we get an actual application. One of the things that a lot of developers like to do from what I've seen in the past is they want to have this big conversation before they actually submit an application, and they will eat up a lot of time. What we like to do is let's get your application. Tell us what you want to do. And then we can start to respond to it, because negotiating against ourselves in this hypothetical world, I find it to be a big drain of time and often doesn't move us toward an end goal. Steve, I don't know if you have any thoughts on that. They're usually eating up your time on that.
Yeah. I mean, throughout the process, I think the planning community is getting more comfortable, I think, with development agreements as a form of controlling zoning. And I know some people are unhappy with development agreements as controlling land use development, but it is something that is becoming more common. So I would just suggest to city staff that your role throughout is try to make sure that you understand what's in the development agreement, work with your attorney, whoever's drafting it, to make sure that you understand what's in there. And if there's something missing, it is your job to make sure that that's included, and that they are things that you can enforce. They're things that throughout, your processes after the development agreement has been signed better than anybody else. And so whether it's the planning department, engineering, or even public works, what is and if you need to specify how that process is, that kind of goes to Mike Malloy's question about can you require a specific type of point of contact or who you're dealing with. You can require whatever you can have them agree to. To Mike's specific question, I think you would find that developers are going to not want to agree to be kind of cut out of the process or to have to work through their designers, architects, engineers. They're going to want to be able to jump in when they feel like they need to. But if you can get somebody to agree to that, go for it. I get where you're coming from on that for sure. But how do you track these requirements over time? Put that in the agreement. How the developer is going to help you track these things over time. What is the developer going to do? For example, with Daybreak, which is kind of an out there example because it's such a large multi-generational development, is we require the developer to stamp plans as they come in. We only deal with the Daybreak Development Group, even though they have builders and others who they are working with. But that is kind of an example, Mike, of something that we have gotten to work where we rarely deal with the actual, except for a building permit stage, but at the land entitlement stage for subdivision site plan, we're dealing with the same development group that we have this relationship with. And their group, their design group, reviews all the plans before they get to us. They stamp it. And they also have a role in tracking land use entitlement over time, how many units they have left, how much park open space they have yet to dedicate, etc. And so having both the developer and the city do that is a way that I think then when the council or others in the community have questions, we can provide them fairly easy answers of what's left to be dedicated, what the entitlement is, and how well things are going.
Yeah, I think that's well said, Steve. Amy, a copy of our template development agreement was posted by Liam. I don't know if you can see that. It was at the top of the webinar chat. And I thought I saw someone else posted theirs, but I'm not sure. And then you say, would it be willing to share a copy? Yes. Also in contrast, what do you recommend never to include an agreement? I'd have to think on that for a minute. Steve, do you have any thoughts on what to never include? I mean, I don't
Something
love
that
the
you're not going to be
assignment.
able to enforce over
Yeah.
time, right? Something that is too complicated or that people are going to forget about. You know, the Victoria's point and also Mike's point about you know, poorly written agreements, vague agreements, or just you do have to figure out a process to make sure that everybody through your review process to the building department, the building inspectors, are aware of the requirements that were adopted at development agreement. And it is challenging. So you got to figure out a way to do that. One thing that we've started doing is we're preparing to post all of our development agreements together with our city code so that they're available and easily accessible to everyone. And I think that has helped. And to your point, Mike, about sometimes pictures are better than words, right? So we rely heavily on the concept plans. Depending on the size of the project, we require more detail in their concept plans. So if it's a small infill project that's needing a development agreement for a very specific thing, usually we can get them to commit to a lot of detail in their development agreement, in their concept plan. You attach that to the development agreement, and then all you have to do in the actual written portion of the agreement is talk about the effect of and the enforceability of that concept plan. And that helps avoid some confusion because some things are hard to describe and a picture is going to be better. In our case, it was too vague of a picture, right? We saw that it had a retaining wall that looked nice, that had some greenery. And again, there was no development agreement in that case. But I don't think planning staff at that point even anticipated that there would be this massive retaining wall at the end of the day. And so the development agreement process does help you think through some of those issues. And I think that's why our council likes it as opposed to other tools.
I think Victoria has some great answers there too. Attorney fees, consequential damages, our remedies provisions, as we've gone through doing this training a few times now. And then Matthew Church, who can join us today, he's outside counsel for many cities and has dealt with litigating these after, would make the point on the remedies provisions. Once we enter into contractual law and we're outside of our normal zoning, we don't have the protections we had prior to that we have under the Utah Governmental Immunity Act.
Yeah.
So from that standpoint, one of the things that we are working on trying to include more and nail down is to by agreement agree that the city has all the immunities it would otherwise have, and that this agreement doesn't remove those. Now, obviously, developers don't like that, but I think Victoria nailed it. Attorney's fees and consequential damages cannot be part of it. Otherwise, the risk is so high, it would be hard to recommend to do development agreements. Had the question, can you go into development agreement after a project's been started? We talked about that a little before. I don't know of any legal reason you can't, although Mr. Brems thought there might be one. And so, John, if you have that statutory site, or if you can refer us to what it is, please post it. But generally, I don't know why most developers would want to bind down their options or limit their options through an agreement if you're not giving them something, and that's more legislative, and that's usually before a project's entitled and going. Another question, are there limits to what a developer can ask for in development agreement, uses, height, etc.? And what about what the city can give as a community benefit? So one of the things Steve and I have had good discussions on is, can the development agreement allow things not authorized by the underlying zone that they're applying for? So if they want to apply for an R5, but then they want, let's say it's residential 5, but then they want a corner of commercial, can you by agreement add the commercial in? And where we've felt safer is, and we have a pretty versatile zone that will allow us to do things like that, is to adopt a zone that allows all the uses in, and then the development agreement restricts the uses down. And so if it's a height thing, they want to go higher, I would have a zone that would allow the height they have, or even a higher height, then restrict them down. Same with setbacks and stuff. I don't like allowing things by development agreement that aren't in the underlying zone. It just doesn't feel like we're following land use principles to me. And to me, that's what it crosses over and feels like contract zoning. I wish Jody Burnett were here to, give his opinion on that, but I just like to avoid that. And sometimes you have to draft, and that's what we had to do with our zone, have to draft with the zone that would allow it to happen, and then use the agreement to limit it down.
And I'll just
Your
add,
thoughts on that?
yeah, I'll just add to that. With all of our development agreements, we obviously have a base zone that's adopted as part of the rezone. And then, like Ryan was saying, identifying if there's some additional flexibility that can be put into the development agreement, whether that's uses or actual physical requirements of development. But
So Steve's saying there's a base zone, then we rezone, and there's a PD overlay zone on top of it, which allows those extra things. So we are adopting another zone, we're layering them.
Yeah, but even in cases where we don't use that, it's very clear in our development agreement that the underlying zone, if there's something not addressed in the agreement, then you default to the underlying zone. And that is helpful for a variety of reasons, but there's just always something you're not going to think about, right? And so when that comes up and you go to the development agreement and it's not addressed, you default to that base zone.
Yeah, and I think you'll see in our draft agreement, we attached a copy of the zone at the time as an exhibit, so there's no question of what that was and what was there at the time. Brian said state statute specifically allows the development agreement to allow things not in the zone. I believe that's a newer change. And Lisa, you had a question about what those changes why those changes came about. And I believe it's 462, House Bill 462. Or 476, sorry. I pulled that up as we were talking. A lot of those were pushed by some of the development community, but they were also pushed by the city's previous language. Really put it on the city attorney to get everybody's or to advise developers of what rights they were waiving in the agreement and stuff. And so we were pushing changes in that, and then more and more things came in as they were negotiating it. Lisa, I think we could talk offline, and I know Todd Godfrey was involved in that too. Brian, I agree with you though. Once the statute now allows it, and I think that's why the planning commission was put in through it to make it a land use process. I generally would avoid putting things in a development agreement, not in the underlying zone or zones. It just, for me, a best practice thing. Then you know what you're talking about with the zone. Do you have some specific do's and don'ts, things to really pay attention to for small cities that have very limited staff, no planners, engineers, etc., and are facing developers requesting development agreements? I think the first question I would ask as they ask for a development agreement is why. If you have a zone, what do they want to do that's not in that zone? Or what do they want? More density? Do they want different setbacks? What is it that they want? And then if I start with their end in mind, then I work back and look at what things protect the city and what things they want, or that what things we would want in order to give them what they want. So one of the other questions that we kind of answered, but there was a little part to it that we didn't, is what is the community benefit? That's one of the first things we always ask when someone asks us for more density. So in the case of the townhomes I was telling you about, they're by the Jordan River, between Jordan River and I-15. I can't remember exact numbers, but if they want 100 townhomes in there and on 10 acres, let's say, so it's 10 units per acre, and our base zone would be 5 or 6 units per acre, and so they want to go up significantly. Well, we can do that, but my council wants more home ownership. And we found out from the developer, they plan to rent out all the townhomes as basically a rental community. So I always look for things like that. On the specific do's and don'ts, I would not, well, and you can't, don't make any promises. Save your legislative discretion for the meeting which you approve the agreement. We've talked a lot about that. I would look at the remedies provisions when you get into if you get into a fight about it later, you don't want to pay consequential damages, attorney fees, or anything like that. You want your governmental immunity to apply as much as possible. Also, if you need more assistance in it, I'd reach out to the league. They have their administrator. There's lots of people like Steve and I that if you have some questions, we're happy to help look through some stuff. And I know there's others.
The other thing that
We're happy to help if you're a small city and this is a case of first impression. Sorry, Steve.
No, you're good. The other part that I was going to add is it may make sense to talk about a text amendment instead of an agreement. If you're a small community, if this development is going to take up a good portion of your community and you don't have a zone that works for them, maybe it does in that case make sense to go through that process, because writing an ordinance is different. It feels different than a development agreement. And the development agreement, you may end up agreeing to some things that you get locked in a way that you wouldn't with traditional zoning. And so again, to Ryan's first point, is ask why, and then look at all of your options, and maybe the best option is not a development agreement, and maybe they will work with you to write a zone that works for the development. And then long term, if it's a long-term development, perhaps those requirements can change as you learn more and as it develops over time.
That's a great point. Meg Ryan's a great resource on that too at the league.
The other thing that I would mention that I forgot to was the role of the planning commission. One of the questions is, at what point do you get public input? Can you have multiple public hearings? Absolutely. And because the planning commission is involved in this process, we try to keep the planning commission out of the specific provisions of the development agreement and help them focus more on traditional things that they're used to reviewing. So the look and feel of the community, getting into specifics like setbacks and other things, rather than trying to get into some of the quote unquote public benefits that are coming as part of the development agreement, things that the council should be focused on. A lot of our processes start with the council in a public meeting. It's a study meeting, but then we go through the public hearings, and usually, depending on the size of the development and the controversy that we expect, we try to have that first planning commission public hearing with enough time before we go to council so that we can come back and perhaps reopen the public hearing at a future meeting at the planning commission, but so that the public doesn't feel like this is a shortened process, but they have opportunity. One question, and I'll just address it real quick, but Ryan was probably more involved with the question, was about, can you get a large undeveloped acreage annexed into the city before you have all the zones in place in a development agreement? And we did that. We did that recently with Rio Tinto, Kennecott, and
just over 2,000 acres.
And they agreed to come in at an agricultural zone with a memo of understanding that we would work together towards something more than that. And so it wasn't a development agreement per se, but it was an agreement that there would be, we would work together towards something more than that base zone.
So I'm putting into the chat from John Brems, he put it in our Q&A, but I don't believe everybody can see that. 109A 532 2D precludes non-legislative development agreements. So I'll just have to look at that more, but thank you, John, I appreciate that. One of the things I'm gonna do is I'm gonna send, as we've only got a few minutes left, our kind of talking points to Liam to get posted, or maybe I'll try to post them. Anyway, in there, you asked, what are some of the essential provisions? I think a default provision, how that happens is essential. Assignment provision, we've had the Daybreak development sold twice since I've been here. And how does that work when they assign it, or what if they sell part of it and not the whole development? Development reporting, one of the things in the recent development we have here is we wanted the commercial tied to the residential, and so we have things like we won't issue building permits beyond 50% until you have so many square feet of your commercial in. Developers really don't like that provision, but our council really wants to get to that point. So where we're not lagging commercial 10, 15 years after the homes are built. That happened a lot in Daybreak, and what we saw a lot is Daybreak was doing a marvelous job of building homes, and then other commercial projects both in South Jordan and in cities adjacent to ours pop up, and then that delays the Daybreak commercial even more. And so we put some of those in. Do you lose governmental immunity across the board, or just for the items in the DA? I think once you've turned, for sure the items in the DA, but once you've turned it into a contractual relationship, you start to put it in question. I don't know that I have a definite answer for you on that because I haven't thought about it a lot. I wish Matt Church was here, but I would say you're taking the risk of losing it across the board. And likely you would. Mention trying to maintain as much government immunity as possible. Does the act of entering into contract with another party put this action under contract law, basically eliminate government immunity? That is Matt Church, who's given this presentation with us 2 previous times. That is his opinion, and he's litigated several of these. So what our advice would be put that in your remedies, put that in that government immunity applies. I'm going to, just for lack of time, I'm just going to cut and paste our talking points into the chat here.
While he's doing that, I just want to add some more to what he said. You really do have to think about maximums versus minimums. What are the things that you want to set the ground floor for that they have to have versus a maximum in terms of units or whatever else, and really think through that. And then the minor changes provision that we talked about earlier really helps you maintain flexibility over time to address unforeseen things.
Yeah. Steve, are there any other questions there? I see Kevin.
I'm sure we missed 1 or 2. Thanks for all the questions. It's helpful.
I will try to, it not allow me to paste those in. Let me just save this to desktop and see if I can do it that way.
I would definitely review that 109A 532. Even, for the non-attorneys in the room, it's helpful to kind of just put development agreements in the context of our land use approvals, and helps you think carefully about when it makes sense and when it doesn't. And then when somebody comes to you, you're more prepared to look at all your options, and a development agreement may make sense or it may not.
Okay, I think it went through my development agreement presentation notes. Those are just some of the things that Steve and I and Matt, and as others, we've done this once or twice, others have given us ideas, we put more stuff in. Happy to talk with you more if anybody wants to reach out directly. Appreciate all the comments and all the lawyering and legal research going on. Appreciate you guys.
Awesome. Great. Thanks, Ryan. Thanks, Stephen. You guys were great. I thought
Someone
this
says
went-
they don't see the notes. So Liam, you've got a copy of them now, right? Or I can send them.
Yeah, what you just sent for the outline.
Yeah.
Yep, I've got them. We'll try and attach the 2 things that Ryan gave us on the video on YouTube. So we'll get that posted later this week and send out a link on Friday Facts as well. Great. Okay, Ryan, Stephen, thank you guys so much. This was excellent. Look out for our Friday Facts where you can see this information, and please always reach out to us if you need anything from us. Thanks so much and have a great day.